Good morning. I hope you can hear me. Wow. I'm having so much fun. I'm asking myself, am I really at a conference? It's really wonderful to have opened up with dancing, but also with a moment of silence, remembering one of the delegates who was here with us today. Your Excellency, Governor Adam, the leadership of the National Museums of Kenya, the Natural Products Industry Program, Dr. Tarancha, the Kenya Copyright Board, Director Training and Research, Ms. Sharon Wata, fellow panelists, colleagues in the business community, Indigenous knowledge holders, all protocols observed. Good morning. I want to begin with a sentence that is also the title of a paper I co-authored in 2023. The sentence is this: just because you can doesn't mean you should. That paper asked a specific question about artificial intelligence and indigenous knowledge in Kenya. The question was whether we should use AI to curate and to preserve indigenous knowledge simply because the technology makes it possible. The answer we arrived at was this, and this will let you know that I'm actually a lawyer by profession. It depends. It depends on who is asking. It depends on what is being protected. It depends on who benefits. It depends on whether the knowledge holders have said yes and a full understanding of what they are saying yes to. So hold that sentence in your mind for the next few moments as I deliver this speech. We have been here this week to talk about turning indigenous knowledge into investment, into ventures, into enterprises for the global market. I think that framing is right. I also think it is incomplete. My job this morning is to complete it. The topic I've been given brings three things together: artificial intelligence, intellectual property, and indigenous knowledge. Each has its own gravitational pull. Or AI pulls towards scale and speed. Intellectual property pulls towards enclosure and exclusivity. Indigenous knowledge pulls towards community, continuity, and context. The global market pulls towards uniformity. Anyone who has tried to bring a traditional product to an international buyer knows what I mean. The first question is never about provenance. It's about price, volume, certification, and consistency. So when you put AI, IP, and IK or TK, whatever you prefer, in the same sentence, you create a tension between systems designed to move knowledge at machine speed and scale, and systems of knowledge that were designed to be moved at the speed of relationships, ceremony, inheritance, and trust. The question in front of us is not whether to engage with this tension. We are already engaged. The Inky Bank was commissioned here yesterday. The AI models that are being trained today, whether in Nairobi, in San Francisco, or in Beijing, are already ingesting African languages, African cultural expressions, African biodiversity data. The question is whether we build our ventures on the right side of that tension so as not to be on the wrong side of it. My thesis is simple. A venture that takes indigenous knowledge to the global market is fit for the market only if it is also fit for the community. because the community holds that knowledge in custody. Fit for the global market and fit for the community are not two separate tests. In the long run, they are the same test. A venture that extracts without consent, that uses AI to strip context from knowledge, that relies on IP frameworks designed to enclose what was never meant to be enclosed, that venture will not survive contact with a global market that is increasingly asking hard questions about provenance, dignity, and benefit. So, I have 3 parts: the AI question, the IP question, and the profitable ventures question. And I will close with a call to action. So my first question: artificial intelligence today runs on data. The quality and the variety of the data determine what the model can do. For a long time, the large models were trained overwhelmingly on English language content from the open internet. That is changing because the value for the next generation of models depends on breadth of language, breadth of culture, and the breadth of domain knowledge. Which means African languages, African cultural expressions, African medicinal knowledge, African agricultural knowledge now sit at the frontier of AI development. Our traditional foods, our performing arts, our oral literatures, our herbal pharmacogens, these are no longer curiosities. From a commercial AI perspective, they are strategic inputs. This is the part where I am expected as a keynote speaker at an investment conference to celebrate. And there is something to celebrate. For decades, indigenous knowledge was treated as backward, as something to be replaced. Now, it is being recognized as the frontier of emerging technology. The recognition is real and it is overdue. But I want to name what this recognition looks like in practice when it is not accompanied by protection. What it looks like is scraping. What it looks like is data sets assembled by people who never asked. What it looks like is a voice model trained on the speech of a Doluo grandmother, deployed as a product with no mechanism by which that grandmother or her family or her community will ever know consent or benefit. The argument in the 2023 paper I mentioned is not that AI and indigenous knowledge do not belong together. The argument is that the question of whether to use AI on indigenous knowledge is a governance question first, and a technical question second. It is a question about who decides, not about what is possible. In practice, 3 things matter. Curation is not preservation. A voice model is not a language preservation project. And we need to distinguish what is actually being preserved from what is merely being captured. Consent has to be layered. Consent to record is not consent to publish. Consent to publish is not consent to train a model. Consent to train a research model is not consent to deploy a commercial one. And context has to travel with the data, because when ritual, when seasonality and dosing traditions are stripped from a medicinal plant use and ingested by a model, what comes out on the other side is a hallucination at best and a dangerous instruction at worst. So when an investor tells me they want to use AI to unlock the value of indigenous knowledge, my response is not a no. My response is, tell me how you're going to carry the consent with the data. How are you going to layer the consent and distinguish curation from preservation? If you cannot answer these three questions, you do not yet have a venture, you have a risk. Now, let's move to the IP question. Intellectual property law, as we practice it today, is built for a specific purpose. It grants a time-limited monopoly to an identifiable creator in exchange for disclosure. The creator is typically one person or one company. The disclosure is typically written. The value is extracted during the monopoly period, and then the work enters the public domain. That is the function of intellectual property. Indigenous knowledge does not fit any of those assumptions. The creator is typically a community across generations. The transmission is typically oral and performed. The knowledge is often not meant to be in the public domain in the Western sense, either during a monopoly period or after it. Some of it is sacred. Some of it is restricted to specific persons. All of it is held in trust for the interest of the community. Kenya has in fact recognized this mismatch in law for nearly a decade. The Protection of Traditional Knowledge and Cultural Expressions Act, number 33 of 2016, gave effect to Articles 11, 40, and 69 of the Constitution of Kenya. Article 11 recognizes culture as the foundation of the nation. Article 40 protects property, including intellectual property. And Article 69, 1C, obliges the state to protect and enhance intellectual property in and indigenous knowledge of biodiversity and the genetic resources of communities. When we read these articles together, the position is clear. Indigenous knowledge in Kenya is not informal. It is not pre-legal. It is constitutionally recognized property. And the Act of 2016 translates that constitutional recognition into an operating framework: protection from misuse and misappropriation, a repository at the Kenya Copyright Board, a requirement that any access resets on prior informed consent, and a role for both traditional or county governments and national governments in stewardship. I want to draw your attention to two sections in particular because they speak directly to the question of how indigenous knowledge becomes valuable and to whom. Section 24 establishes the principle of equitable benefit sharing. It provides that the protection of owners and holders of traditional knowledge or cultural expressions includes the right to fair and equitable sharing of benefits arising from the commercial or industrial use of their knowledge, determined by mutual agreement between the parties. It goes further. Benefits need not be monetary. They may include contributions to community development, responses to the material needs and cultural preferences expressed by the communities themselves. This matters because benefit sharing in Kenyan law is not a discretionary gesture of corporate social responsibility. It is a statutory right attached to the asset. Section 32 provides the vehicle through which that right is operationalized. The authorized user agreement. The Act is clear that where someone wants to use traditional knowledge or cultural expressions outside the traditional context, particularly for commercial or industrial purposes, they must enter into a written authorized user agreement with the holders. It then sets out in Section 34 what that agreement must contain. It must address the sharing of financial and other benefits, compensation, royalties or other payments, the duration and exclusivity of use, disclosure requirements, access arrangements for the owners, any sharing of intellectual property rights arising from the use, confidentiality for secret knowledge, and respect for the moral rights of the traditional owners. Taken together, these three sections tell us something important about the economic nature of indigenous knowledge in Kenya. It is not a free resource. It is not a commons in the public domain. It is a protected category of property, the use of which is conditional on a written agreement that by law must include fair benefit sharing. The valuation of an indigenous knowledge asset for investment purposes must begin from the starting point. What has been missing since 2016 is the infrastructure to operationalize the Act. The statute required a repository. It required protocols for access. It required mechanisms for benefit sharing. The commissioning of the Indigenous Knowledge Innovation Bank here closes the gap between the law and the law in practice, a gap that has left communities legally protected but commercially unserved for nearly a decade. This is a significant moment. The Inky Bank is necessary. It is not sufficient. A repository, even a well-governed one, answers the question of what exists. It does not, on its own, answer what exists, moves into the hands of an investor, a researcher, or an AI developer on terms that actually satisfy its provisions. That movement is governed by licenses, by contracts, by access protocols. If the licenses and contracts are not written with indigenous knowledge in mind, all the protection built at the repository level can be lost at the transaction level. Now, there are two practical pieces of tooling that colleagues and I have been building to sit in that gap. The first is a licensing framework called Noodle, which is designed for African language datasets because the conventional open data licenses and, for example, the Creative Commons and its equivalents do not speak to the concerns of communities whose languages and knowledge are being licensed. They are built for a different kind of creator and the different assumptions of what a public domain is. The second is the governance framework for the Kenya language corpus, which I developed together with Mr. Mark Irura, Dr. Lilian Wanzare, Lois Mboe, and Leo Mutuku, where Noodle governs the terms on which data travels out of community hands. The KLC framework governs how that data is brought together, stewarded, and made available in the first place. It asks how a national language corpus can be assembled in a country with more than 40 languages. Who decides what goes in and what stays out? How communities retain a meaningful voice once their language becomes a part of a national resource, and what the obligations of downstream users are, whether they are researchers, startups, or foundational models trained aboard. Taken together, these two frameworks are two halves of the same conversation. One is a license, one is a governance model. Both sit comfortably inside the Section 22 authorized user agreement architecture. Both put Section 24 benefit sharing principle into operational form, and both start from the premise that neither the default open data posture nor the default IP posture gets indigenous knowledge right, and that something built for purpose is required. Now, my call to action. To the Kenya Private Sector Alliance, to the Kenya National Chamber of Commerce, to CAM and the industry, and other large enterprises in the room, your due diligence checks need to be updated. When you evaluate an indigenous knowledge-based venture, ask for the Inky Bank record, the Section 32 authorized user agreement, the Section 24 benefit sharing agreement, and the governance arrangement with the county. If those documents are not there, The venture is not investment ready. It does not matter how compelling the product is. The policymakers, or two policymakers, the system is not complete. Incubank is one pillar. We still need the licensing infrastructure, the benefit sharing administration, and standard contracts, enforcement capacity, judicial preparedness to handle cases that will come. These are the next pieces of work. To smaller cooperatives and the indigenous knowledge holders at the exhibitions, the tools commissioned at this conference are for you. Use them. Document. License on terms you have chosen. Negotiate with investors from the position of a custodian, not a supplicant. The law, for the first time in this country, is building infrastructure designed to put you at the center of the transaction, not at its margins. As I close, there is a version of this story in which Kenya leads the world on this question, not because our indigenous knowledge is more valuable than anyone else's, but because we have chosen to organize ourselves around it with more integrity than anyone else. That is the version that I am pitching here to you today. And that is the version I hope to see in the business conversations that happen after this conference. And I hope that we choose that version. Thank you.